McMillan.
Thank you very much, Presiding Officer. First of all, I'm delighted to speak today as the convener of the Delegated Powers and Law Reform Committee, the lead committee for the bill, and also for this Stage 1 debate. So I want to also thank the Minister for her helpful reply to the Delegated Powers and Law Reform report and recommendations. Also, the Minister just touched upon that in her comments. Now, this is the third Scottish Law Commission bill that the committee has acted as lead committee for in this session, and it's worth reiterating the point that this is a part of the committee's role and remit which members appreciate and also find very much worthwhile. Just a point that I put to the Parliamentary Business Manager this morning, but also want to make the Minister aware that certainly our committee are always very happy to look at SLC bills. It's a point that we have touched upon in the past also. The Scottish Law Commission bills, by design, are really the most eye-catching pieces of legislation for the vast majority of the population. They are less political by nature, but they're all crucially important to ensure that we actually have a statute book that is very much fit for purpose. But we do believe that the Commission's role in ensuring the law keeps pace with the way we live and work in Scotland is very much a worthwhile one. And the resulting legislation, such as the bill we have in front of us today, is hugely important, and even if quietly so. And I pay tribute to the Commission's work on it. I also think the Judicial Factors, as we are aware, Judicial Factors are an ancient pre-union institution of the Scottish courts. Now, the Minister did touch upon the explanation as to what that judicial factor is, so I don't have to reiterate that. But the bill updates the main current law on judicial factors, which is Victorian, dating from 1849 and also 1889. But it also repeals some even older acts of sediment from the Court of Session. Now, the oldest of these dates from 1690. So that perhaps gives members a flavour of the age and background of the office of the judicial factor, and perhaps also why it was a subject appropriate for the Scottish Law Commission's attention. The Commission's work in the area began back in the 1970s, but stepped up a gear in the early 2010s with its report on which the current bill is based, published in 2013. We were very grateful to the Scottish Law Commission, including its chair, Lady Payton, and former Commissioner Patrick Layden, who led on this report, and also the now former Interim Chief Executive Charles Garland for coming to give evidence to the committee, as we were grateful to all the organisations who engaged with us on the bill. I also pay tribute to my committee colleagues for the way that they worked on the bill. All our recommendations were unanimous, and the committee agreed with the general principles of the bill. I also want to thank the Delegated Powers and Law Reform clerking team for their crucial assistance during the Stage 1 process. There are only around 65 active judicial factories in Scotland, and these are cases open where a judicial factor has been appointed to manage the estate. Now, the number of new appointments is also low, with around only 7 applications for appointment a year. However, we agree with the general consensus of witnesses and those who responded to the call for views that the role of a judicial factor is a necessary one which should be continued. Of course, as with any bill, there are a number of areas we identified where more work may be worthwhile, and I will try to touch upon a couple of the main points briefly. Before doing so, I must also thank the Minister for her response to the committee's Stage 1 report, which I touched upon earlier. But it certainly did agree with a number of the committee's recommendations. I also thank the Scottish Courts and Tribunal Service for their helpful response to the report. Now, one area which we must get right is where a judicial factor is appointed to help manage the estate of a missing person. The bill presents an opportunity to help families and loved ones of people who go missing, and perhaps make slightly easier what would inevitably be a stressful and very difficult situation. The charity Missing People gave compelling evidence to the committee, raising important issues like how practical it would be for a layperson, a family member or a friend to be appointed as a judicial factor, a proposition they supported given cost considerations, as opposed to a professional such as a solicitor or accountant who make up the majority of judicial factors at present. Now, what looking after the best interests of a missing person might actually mean in different circumstances and situations, and also what evidence would be required for a court to accept a person is missing. I'm encouraged that the Minister has committed to creating guidance specifically on the judicial factors in relation to missing people. Now, we are assured that this will cover many of the issues raised by the committee, and that the Government will engage further with the Missing People charity on this. And that's really crucial in order to get this particular bit right. Now, one specific recommendation that we had was that the bill should include an explicit statement that it is competent to appoint a judicial factor to the estate of a missing person. We thought that this was important to ensure clarity on this point. Now, I would be grateful if, in the Minister's summing up, the Minister could actually say more about how this actually will be addressed. Now, further, during the Stage 1 scrutiny, we were encouraged by the willingness that we heard from the Government and also the Scottish Courts and Tribunal Services to adapt and also to review processes to make them easier for lay people to navigate, including in relation to making complaints about a judicial factor. And we hope that the implementation of changes follows in a very similar spirit. In its report, the committee also raised issues in relation to how judicial factories are advertised to those who need to know about them through a register, the data protection and the extent to which such law has sometimes been cited as a reason for information not being shared with the judicial factors, and also the need to obtain the Section 104 order from the UK Government to ensure that the bill gives judicial factors the power that they need to operate effectively. Now, these are all important issues in the bill, which I don't have time to go into in depth, but in relation to each, I'm hopeful that the committee's scrutiny will actually affect the positive change between the initial proposal and what the final act will actually look like. Now, as members will be aware, the Section 104 order is a recurring theme in the SLC bills, which is understandable. So I would be grateful if the Minister can provide an update in a summing up with regards to any communication the Scottish Government has had with the UK Government on this matter. Now, one final point was the issue regarding the McClure solicitors issue and the question as to why a judicial factor wasn't implemented in this instance. The committee evidence on the matter has been very helpful in this regard, and the Regulation of Legal Services Bill also going through the Parliament. It might actually be of more assistance in actually helping protect clients in the future so that they don't have to go through something similar for them. Now, as I said at the start, for some this might not be the most eye-catching bill, but it covers a hugely important part of the legal landscape and it's time for it to be modernised. And thank you.